couple of questions that are in the chat here. I'll get back to the living will one. If you're in the chat here, just note that we actually have YouTube linked to the Will Family Secrets Revealed. I just said that was done a long time ago, so keep that in mind when you look at it. Yeah, that is me in that one. Do we work with same-sex married couples? Absolutely. All of these opportunities and planning all are available for same-sex couples. All right, getting back to a question that is coming from Facebook. It's a question not about a will, but about a living will. What that is this is really confusing. You may have heard the term living will. That has nothing to do with your last will and testament. Though it sounds like it, doesn't it? A living will is an advance medical directive or a healthcare directive. So that is what I call a living document, whereas a will is a document that takes effect only upon death. Your living will is in effect during your lifetime. And what it says is what your wishes are if you are at end of life in a permanent vegetative or terminal condition. Do you want heroic measures or do you not? If you don't have those documents, like an advance directive, a living will, what's going to happen? What's going to happen is that the doctors are going to turn to your family members to ask questions about what does this person want? Do they want heroic measures or not? Well, who are the doctors going to turn to? You know, it's not that uncommon that people don't have durable powers of attorney for healthcare and a living will. So there is a statutory scheme that says who does the doctor turn to first? First, they turn to a guardian. Okay, if there's no guardian, because there's no guardianship, then they turn to the attorney in fact under a power of attorney. We don't have that either yet. So who is going to be next? Spouse? Okay, let's say there's no spouse. Kids. All right. Who? Oldest kid? They look at all the kids. If there's 4 kids, then 4 children are going to be there trying to agree and make decisions about what should happen to mom. And you can imagine that really creates a bit of a problem and chaos for the healthcare provider. So sometimes the healthcare provider actually petitions for an emergency guardianship. So, and then whoever is in this order, this hierarchy, is going to be trying to convey what your wishes are. So again, just like not having a will, not having your living documents, your powers of attorney, your advance directive, your living will, can cause a lot of problems, a lot of angst, a lot of confusion, and cost a lot of money. All right, next question. I know every situation is different, but what is a ballpark figure on the cost of creating a basic will, advance directive, power of attorney, etc.? So everybody's situation is different. For somebody who has a taxable estate or a very complicated, business interest, etc., I'm not speaking to them. But for people that are just saying, my life isn't complicated, I'm married, I have kids, or I don't have kids, but I don't have an estate that's above 2 million, or my spouse and I don't have an estate over 2 million. What should I expect to be paying? Or I'm a single person. What should I expect to pay? This is what I can tell you. You should expect to pay more than $500. You should expect to pay probably in the lower part of $2,000 to $3,000, up to potentially up to $10,000, $8,000, $9,000, or $10,000. Those are kind of the range that I am going to put out, what you can expect to pay. Let me caution you about a few things. When you go to a lawyer, usually lawyers that do a lot of estate planning like we do will tell you exactly what it's going to cost. We will tell you a flat fee. Why is that? Because we understand what's involved. And of course, there are outliers, to both ends of the spectrum, but a flat fee is what you will want to get a quote on, as opposed to the lawyer telling you that they are going to charge you hourly for the services. Estate planning services, unlike Medicaid applications or probates, estate planning services are typically flat fees. Be cautious of somebody who can't give you a flat fee for estate planning. Also, be cautious of people that say, you know what, I'll do that trust for you for $1,500. Oh, you want the asset protection trust added to it? That's going to be another $750. Oh, you want general durable powers of attorney? We're going to add another $1,500 for those. What I'm saying is be careful of that add-on keeps on going up. So by the end of the day, you are at $10,000. Somebody's going to be charging you that much money. They should tell you that outright so that you can make an informed decision about, is that worth it to me? Is that an investment that I want to make? Or should I go shop around? Just like anything, if you're looking for a service, make sure that you talk to the law firm, you interview, you feel comfortable with them, they have depth, so that if the lawyer, something happens to them, if the lawyer dies, that there's a legal team behind them to support your plan. You may want to go interview more than one law firm. We always encourage people, if you want to go interview law firms, please do so. Come to us at some point, come to us last, come to us whenever, because you're really trying to find out, is that law firm a good fit for you? And does it make sense what they are telling you? And do the costs make sense? And is it put in writing? Here's what the fee is going to be. I apologize. That was a huge, long-winded answer to the fee question, but I appreciate you asking it. Thank you. Will a holographic will be enough? Washington does not recognize holographic wills if you created it here. Let me step back. What is a holographic will? So a holographic will can be somebody who is sitting at a restaurant or a bar in a state where that state will say, you know what, just say who you are, where your assets are going, sign it and date it. That's good enough. That's a holographic will. It does not follow any formalities. I'll get to that. So I can't tell you what states do allow holographic wills, but if you are in a state and you create that holographic will and it was valid in that state, when you move to Washington, we will, under the, I think it's under the Equal Protection Act, full faith and credit, we will honor that will, even though if had you drafted it here in Washington, we wouldn't. But if you draft it in a state that does honor it, bring it to Washington, yes, the court should say that's a valid will. I can tell you that it's going to be a very costly probate because you wouldn't have put in it who the executor is, who your personal representative is, that it should be non-intervention probate, they should serve without bond, on and on and on and on. It's a terrible idea to do a holographic will. It will create all sorts of problems. In Washington State, what do we need to have a valid will? Number one, the person who's drafting the will, the testator, the person who's signing it, they have to have legal capacity. They have to understand what they're doing. They have to understand basically what their estate is, what it's composed of, and who are the people who would typically inherit from them, family members, etc. They have to know what they're doing. Beyond that, they need to sign it in front of two witnesses, and those two witnesses and the person who signs the will, they do it at the same time. And then in addition to that, those two witnesses should sign what's called a self-proving affidavit. That's a document that's part of the will, but the notary, there's going to be a notary, so now we've added another person, will say, I saw these witnesses who attested to the capacity of the testator or testatrix, And that way, if it's a self-proving affidavit attached to this will, when the person dies, the will be admitted to probate, all the formalities are met. No, those witnesses don't need to come back into court after the death to say, yes, I saw the testator sign, this is a valid will. Without that affidavit, the witnesses do need to come into court later. And you can imagine years down the road, witnesses might be deceased. So that creates all sorts of problems for a will if we don't have a self-proving affidavit. Anybody who's a witness should not be related to the person who's creating the will. They should not be receiving any assets under the will. So, family members can't witness wills. Those are just some examples of problems when people try to do the wills on their own. Do-it-yourself kits legal in Washington. Yeah, there are. I mean, you can go, you can get kits, or you can sign up for a service. They're typically about $500 or so. Kits can be only $50 or so. And if you follow the directions, the will may be valid if you follow everything that I've described, having independent witnesses and a notary to sign the self-proving affidavit, etc. The pitfalls are, you don't know what you don't know. You fill it out, you follow the forms, but you can bet those forms, those kits were not intended to, avoid loss of an inheritance by somebody who's inheriting from you. There won't be any trusts in it. There won't be any asset protection in it. It's possible that such a kit will be effective and will avoid a lot of these problems. It's just as possible that all these planning opportunities won't be used, because how would you know using a kit? So at the very least, reach out to an estate planning and elder law attorney. A lot of law firms, most law firms, our firm, for example, typically once we've gone through some questions and know that it's potentially a good fit, we'll offer a complimentary consultation. Not always, but it definitely is something that we will do. So really, there's no out-of-pocket cost or risk to you just to find out more. But I would recommend that you seek out an estate planning lawyer, elder law attorney as well.